There's usually one person in a family who does most of the caregiving. They're the one who cuts their hours at work, drives to doctor's appointments, handles the paperwork, manages the medications, and shows up consistently for years. And in a lot of families, that person ends up with the same inheritance as everyone else who didn't do any of that. Your estate plan can fix that. Here's how. I'm Anna Burr with Burr Law. We help families build estate plans that actually reflect their values, including the people who give the most and often receive the least recognition for it. Family caregivers are exactly who I'm thinking about today. Let's start with what's at stake. The average family caregiver in the United States spends more than 20 hours a week providing care, and many are doing far more than that. They may reduce their work hours or leave their career entirely. They may spend their own money on care-related expenses. They absorb enormous emotional and physical strain that nobody measures and that doesn't show up anywhere in a standard estate plan. When that person receives the same share as siblings who contributed nothing, it doesn't feel fair, because it isn't. Your estate plan is one of the clearest ways you have to acknowledge what they give. You can include compensation for caregiving directly in your plan. Your will or trust can specify that your caregiver receives additional financial support, either as a larger inheritance share or as a specific bequest, in recognition of the care they provided. This isn't unusual. It's increasingly common. And when it's clearly documented in the plan with an explanation, it holds up far better legally and is far less likely to create family conflict than informal promises that were never written down. The key is documentation. Verbal promises don't count in Colorado courts. A personal care agreement can make the arrangement official. If your caregiver is currently providing care or will be soon, a personal care agreement is worth serious consideration. This is a legal contract that defines what caregiving services are provided and what compensation the caregiver receives in exchange. Two reasons this matters. First, it protects the caregiver. If they're receiving compensation for their services, a care agreement demonstrates that those payments are legitimate, not gifts, not informal transfers, but compensation for real work. Second, if you ever need Medicaid, this documentation can be critical. Medicaid looks at financial transfers within a 5-year look-back period. Payments made under a documented care agreement are treated very differently than transfers with no paperwork behind them. You can consider a larger inheritance share, but document the reason. Simply leaving a larger portion of your estate to your caregiver is entirely within your right. You do not have to divide equally. Most estate planning attorneys will tell you equal isn't always fair, and fair isn't always equal. What matters is that you document your reasoning. A letter of instruction explaining your decision, attached to your estate plan or kept with it, goes a long way toward preventing a legal challenge and preventing a family rupture. When your family understands the context, they're far less likely to contest it. Appoint your caregiver to trusted legal roles. If you trust someone enough to care for you, they may be exactly the right person to make decisions on your behalf if you can't make them yourself. A healthcare proxy designation or medical power of attorney names the person who speaks for you in medical situations. A general power of attorney gives someone authority over your financial and legal decisions. Those roles align naturally with caregiving, and giving them to the person already doing the work reduces the coordination problems that arise when the caregiver and the legal decision maker are two different people who don't agree. Now, the other side of this argument is that creating a little bit of friction there can help prevent fraud in certain situations. Caregiver fraud is something to be aware of depending on who you have in your life. And so if there is some vulnerability or risk, then you may want to rethink appointing the same person in these roles. Fifth, protect the housing situation. Some caregivers move in with the person they're caring for, or were already living there. If that's the case in your family, your estate plan needs to address what happens to that living arrangement after you're gone. Without planning, the caregiver can find themselves legally required to vacate a home they've been living in for years while they're still grieving. A life estate, a specific bequest of the property, or a trust can all be used to protect the caregiver's right to stay in the home, either permanently or for a set period of time. The family caregiver is often the last person anyone thinks to protect in an estate plan. We think they should be among the first. If there's someone in your family who has stepped up as a caregiver, or if that responsibility is coming, let's talk about how to build that recognition into your plan right away. A plan that's tailored to your family's actual situation and not a generic template. Reach out through the link to call our office. We'll help you put together a plan in a way that's clear, legally sound, and fair to the people who deserve it. Thank you for watching. If you found this useful, please like, subscribe, or share it with someone you care about. You don't want to miss what we have coming up. Every video is designed to help families make smarter decisions about their estate plans. Thank you so much for watching today, and we'll see you next time.